Hello, everybody out in Cyberland. I'm Joe Adams, and with me today is Kevin Edwards. And Kevin and I are both in the Community Association practice group with the firm. Kevin's been with the firm almost 22 years, and I've been here longer than that. We're going to talk today about why you need good governing documents. So, Stephen, you want to go ahead and start our PowerPoint? And let's go to the first slide. Next. So what we're going to try to focus on today is some practical aspects of things that are important, that come up a lot. Just so you're aware, the information for this program was sent to clients only in Southwest Florida and in contacts in Southwest Florida. So, Kevin is in Sarasota. I have offices in Fort Myers and Naples. And the most, if not all, of our participants are somewhere in that region. So to the extent we can localize it, we'll try to do so. I would also point out that our program involves both condominiums and homeowner associations. And it's sometimes the exact same thing, sometimes the exact opposite, sometimes somewhere in the middle. But we will try to address those areas where it's the same, and identify where there are differences. One of the first things you need to understand are what the words we use mean, the terms, the definitions. And the term usually used is governing documents. And, I have clients, all the time say, well, we want to amend our bylaws. Well, they're really referring to some other document. There's really 5 governing documents in homeowner associations, sometimes 6. The main document is the declaration of condominium or declaration of covenants in an HOA. It is kind of the Constitution. It sets forth the basic rights and responsibilities, duty to pay assessments, obligation to be a member of the association, etc. The Articles of Incorporation are sometimes called the Charter. They're basically like a 2-page boilerplate legal document that really establish the association and defer to the bylaws. The bylaws are what I call the corporate housekeeping rules. How many people are on the board? How long do they serve? When is your annual meeting? Do you follow Robert's Rules of Order? Can the board pass special assessments, or do you need an owner vote for it, etc.? The rules and regulations are, kind of what we call the do's and the don'ts. The declaration will contain the basic use restrictions, single family use, no more than 3 leases a year or whatever. But the rules and regulations are kind of the more detailed stuff. Don't park in this area, or no trash down the chute in the building after 10 p.m. or whatever. Sometimes called house rules, but those are rules and regs. Policies and rules and regs in HOAs, you usually, or at least often, have a second subpart or maybe a separate governing document called the design review guidelines or architectural guidelines, something like that. And they basically deal with if you're going to modify or improve your home or your lot, the standards that you have to follow, what kind of roof materials you have to use, that kind of thing. And then finally are the policies and procedures. And the policies and procedures are adopted by the board, for the board, and they're kind of what I call the board's operating manual. What forms do we use? What's our lease approval form? What's our sale approval form? How do we deal with owner records requests? How do we deal with remote meetings? How do we deal with owners' rights to speak at meeting? What's our estoppel form? What's our fining procedure? Those are all kind of the policies and procedures. So, as you can see, within those 5 or 6 governing documents, there's a lot of stuff covered. I mean, it is basically the soup to nuts of what your association operates under. The statutes are there, but in some cases, the statutes just provide a floor or minimum standards to follow. In a lot of cases, the statutes say, unless otherwise provided in the documents, and in a lot of issues, the statutes are just silent. So we're going to jump in, next slide, to the declaration. And Kevin, you do a lot of amendments and complete rewrites of declarations for clients. So starting with condominiums, and then we'll move to HOAs. What would you say? I won't ask you for a David Letterman top 10, but I'm going to ask for a Kevin Edwards top 3 or 4. Why don't you tell me, when a client sits down with you and says, we have 35-year-old documents and we want to update them to modern standard. What are the 3 or 4 items you almost reflexively focus on?
Well, without a doubt, Joe, the first one that we get all the time are transfer restrictions or sale and lease restrictions. What can we do to tighten up, or our approval process, or can we establish an approval process? We want to be able to determine and basically have some guidelines in place so that we can review sale applications or lease applications. That's probably number one we get. Number 2, we get probably, what can we do to keep out pets? Okay, that's another big one, is the pet restrictions. Can we, tighten our pet restrictions, or can we create some additional pet restrictions? And probably the third most popular that I get anyway is probably, what can the board do insofar as material alterations to the common elements in condominium associations? So those are pretty popular, and I'm sure you see this.
And why don't you? Because material alterations is an issue we get constant questions about. Why don't you basically explain what a material alteration is, what the law says, and how your declaration can make material alterations a lot easier, if you want to use that term?
Yeah, I mean, a material alteration, we're talking about, in a condominium context, the common elements. And material alterations to the common elements, are anything that, palpably or perceptively changes the use, function, or appearance of a common element. And that's basically the definition of a material alteration to the common elements. And board members.
So changing from a shingle roof to a metal roof is typically a material alteration.
Yes, it is. And changing the exterior color of your building is a material alteration to the common elements. And the law, the statute in 718 says that unless your documents provide otherwise, unless your declaration provides otherwise, the board can't make material alterations to the common elements without the approval of 75% of the entire membership, the entire voting interests.
Is that 75% of those people who send in a proxy or come to the meeting?
No, it's 75% of everybody, the entire voting interest. So that's pretty tough unless your documents, say something different. So that's why a lot of times board members who may want to be able to make some material alterations to the common elements, the statute says they need 75% of unanimous approval. Everybody, that's pretty hard. So they may say, well, we want to try to amend our documents to lower that requirement. Or let's say what I get a lot is, we want the ability to make some material alterations up to a certain monetary limit without getting the approval of the unit owners. So that's something you can do, when you talk about rewriting or amending your governing documents. Boards may want to make it a little easier to make some material alterations to the common elements.
What are the most common provisions you see as far as what triggers an owner vote requirement if the board is given some authority over alterations?
Well, I mean, what triggers the unit owner, it's usually a dollar amount. okay, could trigger it. Sometimes we see, basically the number one is the dollar amount that I've seen is the board can approve certain types of material alterations up to a certain monetary level or percentage of your budget perhaps, and then that would trigger membership approval. Sometimes you see, if it requires a special assessment, that may require membership approval. So I've seen those types of situations in the documents.
Okay, so a couple of things. Number one, I am reviewing the questions that come in. For cooperatives, basically the condo law is going to be 95% of the time same concepts. You don't have a declaration of condominium. Usually you'll have a master form or proprietary lease. Sometimes the bylaws of a co-op will include a lot of what a declaration of a condominium will, and the statute allows that. I'm going to shift gears here and talk about kind of an esoteric legal issue that when I talk about clients, they kind of glaze over and say, yeah, whatever. I don't really understand what you just said. And that's what law applies to your association. And the reason this is important is because there is a lot of court cases based on constitutional impairment of contract issues that say the law that exists when your condominium is created is what you follow unless your documents incorporate future changes to the law, or unless the change to the statute is procedural. And, procedural is kind of in the eyes of the beholder. The statute now says, for example, it was amended this year to say you have to give 14 days notice for special meetings in a condo unless your bylaws provide otherwise. That's procedural and clearly applies. But the importance of this issue was highlighted by a recent appeals court case that came out probably about 2 months ago. And in that case, what was at issue was the ability to suspend voting rights for non-payment of assessments. The statute was amended, I think, in 2008 or 2010, after, in connection with the big meltdown we had, to state that if somebody isn't paying their maintenance fees, you can suspend their right to vote, and you don't count them toward your quorum or required votes or anything else. And, I would have thought that was procedural, but there was an appeals court case where an association tried to suspend a delinquent owner's rights. And the court said, no, the right to vote is a substantial or substantive legal right. And the legislation from 2008 cannot be applied, or 2010 cannot be applied retroactively. So the association lost the case. And I can tell you, I have a lot of associations that, have suspended voting rights when someone is delinquent. It's not an issue we see as much as we did, 10 years ago, fortunately, but, it still comes up. And so that's the kind of thing that, you really don't appreciate until it becomes an issue, fining, other things so this case really creates kind of a Pandora's box. And why in updating your documents, and this is your lawyer's job, you need to be really attentive to how you apply the Florida statutes. I'm going to make a couple other points on the declaration, and then we'll move along. In my experience, probably the most important provision in the declaration, and the one that almost always needs the most work from the developer boilerplate documents, is the maintenance sections. I mean, you'll see the association maintains the common elements, the owner maintains the units, but the windows may be part of the common elements and everybody thinks the owner maintains them, or, balcony screens, railings, sliding glass doors, doorbells. I mean, you name it. And in my experience, the typical developer set of documents leaves a lot to be desired in that regard. And, these can become expensive disputes. And as one of my partners likes to say, if you need to call a plumber to fix a plumbing line, you don't want to spend 3 times more than the plumber's bill on a lawyer's bill to figure out whose it is. You should be able to pick up the documents, read them. These terms should be written in pretty clear, non-legal lease terms. These aren't legal lease issues. And it should be clear. So that's an important one. On the leasing issue that you raised, Kevin, also something I get a lot. And one thing that I think most people understand or realize, but just in case, the condo statute was amended in 2004 to state that if you change rental terms, it does not apply to anyone who doesn't vote for the amendment, if they vote against it or don't vote at all. Now, there's a question of this new case, whether that's retroactive if you're a pre-2004 condominium, but most associations follow that. Also, for those of you that attended the legislative update that Ken and Director and I did a few weeks ago, and all of these programs, by the way, are available from the firm. They're all recorded, so if you want to look at it again, if you have some kind of a death wish and want to watch this twice, or one of your other directors want to watch it, you can get it from us. But the HOA Act's been amended this year to also impose a rental grandfathering provision. So with that, I'm going to shift into provisions we see in HOA declarations and that we're updating. And again, I'm going to ask for the Kevin David Letterman top 3 or 4 list of issues that you come across when you're updating an HOA declaration.
Yeah, the HOA documents, what we typically see and routinely will see are architectural review criteria, meaning, the associations want to be able to amend their documents to, either create an architectural review committee if they don't already have one, or to expand upon the powers of an architectural review committee and put in the documents some, criteria for, owners to follow when they're trying to install landscaping or maintain their yards or install improvements on their property, what they can and cannot do. So that's a big one for homeowners associations, certainly. Basically, we also will see, like I said before, pet restrictions. That's a big one too in HOAs. And basically, material alterations aren't really much of an issue in a homeowners association, so we don't, typically see that in an HOA. But essentially, architectural review requirements and finding issues will come up with the homeowners association as well, establishing a finding committee and describing the process involved if you don't want to go, or using an alternative to filing lawsuits all the time. You may want to avail yourself of, finding and suspension of use rights. And we see that type of amendments in play as well, quite often with an HOA.
Okay. And I would add, rentals is also a big issue in HOAs, probably more so than condos. We're seeing a lot of Airbnb type of issues in HOAs, but in condos as well. Different condos have different abilities to control that kind of thing. If you have a high-rise building with an attendant at the front desk and they don't let them in, that's different than a garden villa condo with no gate. I mean, people can just come and go. And these are issues that exist in both condos and HOAs. And again, a carefully crafted set of documents is kind of important. What is a lease? Technically an Airbnb use is not a lease because you license Airbnb to allow people to use that unit. You're not leasing it to them. I would argue it's still a lease, but you can certainly avoid having to make that argument by using definitions in your documents. Other issues we see, a fair amount are issues that aren't a traditional lease or Airbnb, but uses by people the owner doesn't know that do not involve the direct payment of money, but still involve what I would call, quote, legal consideration. A couple examples. I donate my home or my unit to, my kid's school charity auction for the Chinese raffle, a week at my Florida condo. I write it off on my taxes. I mean, I don't know who's going to get it. Is that not a tenant? They're not paying me rent. But I would argue there's a tenant. Home exchanges. You can use my condo in Sarasota for a week, and I can go stay in your cottage in Edinburgh for a week. That kind of thing. Employee perks. And we see a fair number of situations where, some company buys a unit and they'll send their, salesman of the month or their best supplier or whatever down there, and everybody comes to Florida for a week and it's party time. And they'll argue this isn't a renter. I'm not getting any rent out of it. So again, you need to be, precise as you can in your definitions. And you also need to dovetail that with what I call guest restrictions. The issue of someone being able to use your property when you're not there. And this is sometimes controversial because, hey, my home's my castle. I paid good money for it. I can decide who uses it and when. But in a condo or an HOA, you give up some of those rights. And, particularly with the, Airbnb types of cheaters, they just say, oh, he was my guest. And, by the time they're there and gone, you have no idea what was happening. So what I found is that associations can do to kind of close that loophole is to put in the declaration of covenants or condominium, or in co-ops, the bylaws, a guest restriction on, how many times a year you can have guests. Most of my clients want to say, hey, if it's my family, they can come whenever I want. I want my grandkids to come use my Florida condo, that's kind of, open door policy. But for unrelated guests, a lot of associations say you can't do it at all. Or I have a lot of clients that limit it to maybe 2 times a year. So if you want your college roommate or your parish priest or rabbi or minister to use it, or, your wife's best friend from nursing school or whatever, you can do that, but twice a year. And that way, kind of cuts off this, revolving door kind of thing. The other thing I would say in HOAs that really bears some study is what is the parcel and what is common elements, because usually in an HOA, at least if it's a platted subdivision, the road right of way will often be fairly wide, much wider than the pavement. So the people's front yard is technically a common area. They may have their mailbox there. They probably have their driveway apron there. There may be trees there. You also get into drainage swales and easements, ponds in the back, lake maintenance easements are all common areas. But, the property itself may be, part of the lot. So, just kind of using, boilerplate or lazy lawyer language is not going to, solve or help you address those kinds of things. So, by far, the declaration is, kind of the big kahuna, which is why we're spending, half of our allotted time talking about it. And frankly, we kind of, scratch the surface here. Sale restrictions. Can you do criminal background checks? Insurance requirements, all of those things are, important. And, probably one of the most important, and what I'll end this on, is the procedure to amend the documents. I see documents that say anything. The declaration can be amended by a 2/3 vote. Well, does that mean 2/3 of everybody or 2/3 of those who vote? It's not that hard to make it clear. If you want it to be 2/3 of the entire voting interest or 75% of the entire voting interest, easy enough. Use those words. If you want it to be 2/3 or 75% of those present in person or by proxy at a meeting where a quorum is established, then say that. Easy enough. You've got a chicken and egg if your documents are unclear or onerous now. Sometimes the best strategy is when you talk to your attorney is to go through the current amendment provisions and decide whether they need to be cleaned up before you spend a lot of time and money, kind of rewriting the documents as a whole. I do that for a fair number of clients. I'm involved in 2 or 3 of those that are kind of ongoing as we speak. So we're going to shift gears. We'll come back to this if we have time. Next slide, please. All right, let's go through this. We kind of talked about the declaration. So next slide. All right, the Articles of Incorporation are, like I said earlier, kind of a 2 or 3 page boilerplate document. I've seen articles that, that say how many people are on the board, their terms, limits on borrowing authority or special assessment, those things. I think a lot of developer lawyers feel like their clients pay them based on the number of pages. I've seen like 18-page articles of incorporation. You don't want that or need that. Your articles of incorporation really, should just follow the statute that only require them to contain 6 or 7 things. Who incorporated it? Who are the members? Does it have a perpetual duration, which they all do? How do you amend it? And the only thing that's kind of substantive that I normally put in bylaws is what's called the indemnification provision. Indemnification is very important. We do have a program called Covering Your Assets about liability in connection with serving on an association board. And I won't get too deep into the weeds on that issue today, but it's important to note that the indemnification clause is what requires the association as an corporation, an entity, at its expense to hire a lawyer for any director or officer who is sued, and also to pay any judgment that is rendered against them. There are some limits on that, but that deals with fraud, self-dealing, some forms of intentional discrimination, and things like that. But that is an important clause. It's really not one that the association, the client, needs to spend much brain power on. I mean, your lawyer should know how to write it to provide the maximum protection for the volunteers who serve on the board and the officers of the board. And I also include committee members in the indemnification provisions that I write, because if the board appoints someone to a committee and they get sued for whatever reason, which doesn't happen often, but it does, they should also be entitled to be held harmless for their volunteer service. Next slide, Stephen. The bylaws, as I referred to earlier, are what I call the corporate housekeeping rules. And the Florida Bar Manual on Condominium Drafting has a model set of bylaws, and they're really an excellent document because I wrote them. And I joke, no, I did write them. But, a lot of the things in the bylaws, more for condos and co-ops than HOAs, are set by default. There's not a lot of areas where there is room for, choice, or where most associations at least want to, talk about choice. But let's talk about, some areas in the bylaws, and I think this kind of is generally applicable to all three kinds of associations: condos, co-ops, and HOAs, without a lot of distinction, some fine point distinctions maybe on board service and stuff. But what's the Kevin Edwards top 4 on issues that clients ask you about when updating their bylaws?
Pretty much, Joe, the number of directors. They may want to increase or decrease the number of directors. They may want to, especially in a homeowners association, they may want to describe the election process for homeowners associations and pretty much follow like the condo election process. We don't have to go into a great amount of detail on that, but basically for an HOA, it's pretty much the Wild West when it comes to what you got to do during your annual meeting and election, versus condos. It's strictly governed by the statute. You have to have the 2 notice requirement and secret written ballots and all that for condos. So a lot of times HOAs come to me and they say, well, we want to specify an election process and we want to follow the condominium process. So I get a lot of that, and amending the bylaws, changing the annual meeting date and time and location.
I'm sorry to interrupt you. Let's talk about election procedures for a minute, because this is probably, one of the areas where each association's bylaws does require customization and some choices. So what about term limits? What can you have term limits in condo bylaws, and is there a term limit in the law?
Well, the law, Joe, as you know, the law as of, I think it was 2 years ago, basically says directors can't serve for longer than 8 consecutive years. Okay, well, there's some exception to that. They can if, they get elected by, a supermajority amount of the votes, or if there's nobody else willing or able to run, that would be an exception. But yeah, in condos, there are that 8 consecutive year limitation for condos. So we will.
And this year's legislation said that cleared up a long-standing debate. It's retroactive to July 1, 2018. Right. So in counting your 8-year term limits in a condo, you start with terms in existence, or that terms that started after July 1, 2018. So let's say you want to put a 4-year term limit in your condo bylaws. Can you do that?
In the condominium bylaws, yes, you can put a 4-year limitation, sure.
Okay, so let's talk about HOAs. Is there a statutory term limit there?
No, there is not.
And can you put a statutory term limit in your bylaws?
Yes, you can.
I don't know. I think that's a debatable point.
Okay.
Because it's almost a flip-flop. Everybody used to say you could put term limits in HOA, but not condo, because condo says any unit owner can put their name into nomination. Then they amended the condo statute to say, but you could have term limits in your bylaws. They also amended the HOA statute to read more like condo. That says any parcel owner is eligible to run. So, that's an area that needs to be clarified by the legislature, because, it's almost like, incomprehensible. They swapping these things around. Why would term limits be okay in HOAs but not condos, and now they're okay in condos but not HOAs? But that's an issue to look at. And as you mentioned, the election process, you can still use proxies in HOA. You can still use a general proxy in an HOA. That's been illegal in condos for 30 years. So, and I think the system that condos use, most HOAs like. It's fair, it's anonymous, and everyone who wants to run can. So let's talk a little bit about board terms. What do you see as the most common size of a board, and the average, term that is generally considered desirable on an association board? 20-year terms like prison?
No, God forbid. Most times board sizes, for example, even with larger condos, I think, pretty much on average, boards usually run between 5 and 7, maybe sometimes 9 members. I don't see too many boards that are larger or smaller than those numbers. I mean, yeah, there are some exceptions.
5 and 7 seem to be the two most common numbers, right?
Yes. And then terms, I mean, in a lot of condos, I still see for condos that they serve only 1-year terms, or some of them will serve 2-year staggered terms, which is pretty popular. We don't see generally too many provisions where they're saying 4 or 5-year staggered terms or something like that. Certainly not 8-year staggered terms. I haven't seen, and that's pretty much the same in HOAs too. It's pretty much either 1 year that expires at the annual meeting, or 2-year staggered terms are the most popular.
Okay. So so that's certainly one area where the bylaws can give some choice. But frankly, in most other, some associations want to have their annual meeting the second Tuesday in February at 4:00 p.m. because that's the way they've always done it. I mean, you can do that kind of thing. We kind of advise against it. There's nothing in the law that requires that. And that's, of course, the day that the board president just won a free cruise to Tahiti and, can't be there. And, you get into all of that kind of thing. So in my view, the best practice is to kind of leave the bylaws generally tracking the statute and not impose more, criteria on the board or the association than the law requires. For example, I get a lot of clients who say, well, the statute requires competitive bidding for any contract over 5%. We want to have every contract bid. Let's put it in our bylaws. Well, I don't recommend that, because 5 years from now, there's going to be all new board members and nobody's going to remember that's in there. And, something's going to happen where it's not done. And then some owner wants to contest something. If the board wants to competitively bid every contract, that's fine, but adopt it as a board policy, not as a provision buried in, 23 pages of bylaws that, 5 years from now, nobody's gonna remember is there. So let's go to the next slide, Stephen. All right, so let's move a little more quickly to the remaining governing documents, and let's talk about the rules and regulations. And Kevin, let's start with kind of a 30,000-foot view of the Beechwood Villas versus Poor test, as we say inside the office, as to whether a board can adopt rules, what kinds of rules the board can adopt, what limits are on the board's rules, and let's take it from there. So let's talk about board rulemaking authority.
Okay, in many cases, most cases, the boards have the authority in the governing documents to adopt rules. Okay, I mean, obviously, if you don't have that authority, you can't adopt rules. So it's important.
Right. Well, stop there. It's not so obvious to many people, including a lot of attorneys. The statute does not confer rulemaking authority on the board, except in limited circumstances. Like you can adopt a rule about how people inspect records and, maybe a half a dozen things like that. But there is no general grant of authority in the statute for the board to adopt rules. It has to flow from your governing documents.
Right. So that's correct. So if, first of all, you want to look to your governing documents, make sure you've got that authority. And if you don't, you may want, it's another, good idea then for a reason to amend your documents to give the board rulemaking authority. So number one, if you've got the rulemaking authority, okay, then the boards can adopt reasonable rules. Now, when we say reasonable rules,
let's go backwards, because one of the things that I see is you can say the board can adopt rules, but in associations, there's two kinds of rules. There's rules regarding the common elements or common areas, and there's rules regarding the units or the homes. Common area rule says, well, the pool opens at 9, we're changing that to 8. A unit use or a home use rule says if you're going to have a guest come and you're not there, you have to register them 10 days before they get there with the manager. So it's important to very carefully read your documents to see what rulemaking authority is given to the board, because I see a surprising number of documents that only give the board rulemaking authority as to the common property, not to the homes or the units. So, if you don't have that authority, you don't pass go, you don't collect $200, you don't go to the next issue because you lack the authority to adopt rules regarding unit use. So let's assume, for the sake of discussion, that the documents give the board the authority to adopt rules regarding both the units/homes and the common elements, common areas. What's the next thing you look at?
Well, then the next thing you look at is basically, you look at your governing documents to make sure that board rules are not going to contravene or contradict anything that's presently like in the articles, which would, be not really be the case at all, or the bylaws or the declaration, most importantly. For example, if the declaration says no commercial vehicles, the board would not be able to adopt a rule that says, okay, well, now we're going to permit certain commercial vehicles. Okay, that would be in direct conflict, and the rule would not then be reasonable or enforceable because it would be in direct contradiction to the declaration. So you got to
this is a pretty subtle legal issue that we pull our hair out about. There's no bright line. What the case law says is you cannot adopt a rule that conflicts with the declaration or any right which is inferable therefrom. So the first part's easy. If the documents say that, no owner may have more than 3 pets, the board can adopt a rule that says no owner may have more than 1 pet. That's kind of a no-brainer. But what's inferable from a declaration? There's one case where the declaration said an owner can lease for a minimum period of 30 days. And then the board adopted a rule that said, and an owner can only rent 4 times a year. Well, this case was adjudicated in arbitration. The arbitrator said, no, that rule is no good because inferable from the right to lease for 30 days is the right to do it 12 times a year. So the board's rule of 4 times a year violated a right that was inferable or inferable from the declaration. So you have to be careful about that. And then finally, the rule has to be reasonable, which is, kind of what lawyers fight about. Also, in both condos and HOAs, a rule that affects unit use or parcel use has to be subject to a board meeting where notice is given 14 days in advance, both by posting and by actual notice to the owner, by mail or hand delivery or email if they've agreed to receive their official notices by email. So, that is kind of a procedural requirement that we see missed all the time. And I'll get a rule, sent to me that, is a problem, somebody's violating it. And I look at it and say, I've never seen this before. And, send me the notice where it was adopted. It was a 48-hour adoption. The rule's no good. Maybe if it was done 10 years ago, the statute of limitations might preclude that problem. But if it was done within 5 years, the owner is going to have a defense to the enforcement of that rule against them because it had to have been adopted in the manner set forth in the statutes. So, the rules and regulations in my view, you have to, first of all, distinguish between rules involving the unit and the common elements. The common element rules are pretty common, playing basketball in the swimming pool and, spitting on the sidewalk or whatever the case may be. Parking, picking up after your pets, all of those kinds of things. Before we move off the rules and regulations, one of the things that I always feel is important to point out to clients is rules involving children. I probably almost never review a set of rules that doesn't have some rule on children. And the problem there is that unless you are a 55 and over community, having minor children is what's known as familial status. And that is a protected class under the Fair Housing Act, just like race, color, creed, national origin, and all in disability. So what the courts have said is that any rule aimed at children has to be narrowly tailored and cannot be and has to be the least restrictive means to address the issue. There's cases that say all children outside the unit under 10 must be supervised was illegally discriminatory. I see rules that say things like, no minor may be on the common elements without parental supervision. So that means that, my 17-year-old son who's a Rhodes Scholar and on the Olympic swimming team and going to Yale needs his mother to walk him to the school bus, right? Obviously that is, discriminatory. I have a great son, but he's not going to Yale or on the Olympic team. But the point is that even the existence of that rule under the case law, whether you would enforce it or not, under a U.S. Supreme Court case from 4 or 5 years ago called Texas Housing Authority, even the existence of a discriminatory restriction is discrimination. And I can tell you that discrimination cases are a real bummer to deal with because, number one, it's probably the only area where directors and managers are named personally as defendants or respondents. Number two, the cases are brought by the state or U.S. government, who's got all the money they can print. And number three, insurance coverage is always an issue because under Florida public policy, you cannot insure against intentional discrimination. You can insure for the defense. So, word to the wise, when you're updating your rules and regs, take particular note of those. Another, area where you need to look at your rules, a lot of things. For example, the Florida law requires all condos to have hurricane shutter specifications. Probably the majority don't. So if an owner wants to go slap up purple, tin shutters and you don't have specifications, you're going to have a problem stopping him or her from doing that. Rules on satellite dishes, they're pretty heavily governed by federal law. You can't prohibit them. You can't actually even require board approval for them. You can only establish location preferences. So, these are all things to look at. Let's talk, Kevin, about design review guidelines for HOAs. And we touched on this earlier, but, what are, kind of some of the general topics that you see that associations might want to put in the DRGs, the design review guidelines, that wouldn't be appropriate to include in the recorded declaration of covenants?
Well, I think it's, the specifications, what exactly are permitted insofar as, let's say, homeowners who want to put fences up, homeowners who want to install pools, homeowners who want to install or do landscaping or make other improvements to their lots, what they can do insofar as the amount of trees they may want to put in, or the specifications of the fence, or a shed, if that would be the case in HOA. Okay, lamp posts, what kind of a style and color of lamp posts can the owner install? These types of things, basically telling the owners what they can and cannot do, or what they need to do if they want to install these types of improvements on their lots.
Right. Yeah, I agree with all that. And, things that I think are Also appropriate for the design review guidelines are the contractor rules. Do they need to have their own toilet on the job site if they're going to be doing like a major, going to be there for a month? Are there limits on, how early and late they could come? Are there limits on, having to sweep up streets after, they bring in heavy equipment? Some associations require damage deposits. That should really be in the declaration. And, we see a lot of landscaping guidelines in the DRGs. That's kind of all over the place because a lot of municipalities have their own requirements. The Florida Homeowner Association Act, Chapter 720, also says that you cannot prohibit what's called Florida friendly landscaping, FFL. FFL is different than Xeriscape. Xeriscape's kind of that, Arizona rock yard thing. FFL isn't that. FFL is based on using local sustainable plants like native types of grasses and hedges and things. There's a fair amount of material on what FFL is, but you can't require people to have the old standard Bahia sod lawn that has to be watered 3 times a week if they want to put in something that is proper Florida friendly landscaping. So okay, so we have 7 minutes left, and let's just take kind of a quick run through policies and procedures. And why don't you pick a couple of policies and procedures that you normally recommend for clients, and tell us why you think they're important to have.
Well, you can see some of them here. Obviously, fining procedures are very important if you're going to, if the board is going to want to take advantage of the ability to fine. You got to follow the statute pretty much exactly in order to do that. But it's a good idea to have that type of fining procedure in a resolution or a policy or a procedure that the board, or as stated here, an operating manual for policy and procedures for the board. Basically, records access is always a big one. To designate basically some rules concerning when owners can access, how many times they can make a request for access of the governing documents. Unit owner membership meeting and board meeting rules in governing how many times the owners can speak, how long they get to speak. These are all basically, important issues that I've, had quite often with clients wanting to tighten up that process so that, owners don't get to talk, for example, at a unit owner or a board meeting for 20 minutes. They're limited in scope. And, some of them, for example, have policies that require owners to submit questions ahead of time, that if they want to be heard at board meetings. So that type of stuff, those types of policies. Collection policy is important also. Same with an enforcement policy. You want to put that, exactly when the process will begin. When is a unit owner going to be considered delinquent in the payment of assessments? Is there going to be any type of a grace period before they're considered late or delinquent? What's going to happen when an owner is in violation? Is it going to start with a letter from the association, or is it going to go directly to legal counsel for enforcement? Those types of issues are important that to have in board policies and procedures.
Yeah, I'm going to give you a couple of examples of things I've run into. I see a lot of documents that say if you're delinquent, the board may levy a late fee of $25 or 5% of the installment due, whichever is greater, which is what the statute says. Well, the board goes and puts a late fee on, and it goes into legal collection, and the attorney for the owner says the board may. Show me the minutes of the meeting where the board levied a late fee on this account. Of course, they don't exist. It's done by the management company or whatever. So by having a uniform collection policy adopted by the board, you've got it. It says every time this account is 10 days delinquent or whatever, your documents say and your policy says, there will be a late fee added. So you have, kind of a, a ready-made, standard policy. Another issue I see a lot is, all right, well, so-and-so rented and he won't fill out our application form. He thinks it's too, nosy. So I say, okay, give me the form. I look at it and say, okay, show me where the board adopted the form. Well, nobody can ever find that. So if you have, as part of your board's operating manual, your policies and procedures, a schedule of your forms, then again, you don't have the ability of the owner to raise that defense saying they're making me fill out a form that they never even adopted. I don't know where it came from. A lot of associations just get their forms from their management companies, and the manager emails it to the president or the treasurer, who's ever relevant, and the officer says, yeah, it looks good, let's use it. If you get into a legal hassle, that's probably not going to be, good enough. So basically, that is in 58 minutes what Kevin and I have spent the last 57 years between us doing every day to feed our families and put our kids through college. We would like to thank you all for listening throughout today's program.
I just want to say one thing before we leave. Thank you again, everybody. And I think, what we tried to discuss for the past, 59 and a half minutes now gives everybody a good understanding, or at least some understanding, of why it really is important to have good governing documents. Okay, these are just some of the issues that come up if you don't have good governing documents. So it's very important that, if you want to update or amend your governing documents to, see if you've got any of the types of provisions that we talked about, to have your legal counsel certainly review rules. Very important with the discrimination stuff out there ready to bite you. But I mean, I think, we tried in the hour that we had allotted to pretty much explain why it is important to have good governing documents. So that's all I wanted to say, and it's very important, obviously.
Thank you, Kevin.